Hey everybody, John Skiba here, and in this video we're going to go over 3 things that you can do if you happen to lose your debt collection case. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on the little bell there, that way you get notified each and every week when we put out new videos to help you deal with your serious debt problems. Alright, let's talk about if the unthinkable happens. Let's talk about if you lose your debt collection case, what some of your options are. If you're new here to my channel, you're going to see we talk a lot about different strategies and tactics and approaches to try to beat the junk debt buyers that are filing all these debt collection lawsuits. And as I mentioned before, there are some strong defenses out there that can put you in the best possible position to win your case. That being said, there's always a chance you're going to lose your case when you go to trial. If you ever meet with an attorney and they tell you that they've won all their cases, you need to run away because they're lying to you. Every attorney loses cases. Every judge is different. Juries are different. The law is different. Cases can turn on little small things that you wouldn't think that they would turn on. And so every time you go to court, there's always a chance you could lose. If you don't think that's the case, look at the O.J. Simpson trial. I always bring that up. You go back and you watch that and you think, how in the world did the prosecution lose that case? Cases turn on different things that maybe you're not anticipating, and there's always a chance you can either win or lose when you go to trial. So in this video, I want to share with you 3 things that you can do if you happen to find yourself in the unfortunate position of losing your debt collection case. The first thing you could do is you can appeal the ruling. Most courts, even justice courts that are kind of the lower courts like here in Arizona where I practice, they provide an opportunity for you to appeal the case to a higher court to have another judge look at it to determine if what the lower court did was correct. Now, the first thing you need to know is that in most situations where there's an appeal, you have a very limited amount of time to do it. So for instance, in the justice court system in Arizona, once judgment is entered, you have 14 days to appeal that judgment. If you don't appeal the judgment, it's final. You can't appeal it down the road, you're done. In the Superior Court here, which deals with cases of more than $10,000, you have 30 days to appeal that judgment to the higher court. Otherwise, it's done. It's final. So you need to find the rules, and it's usually in the rules of civil procedure or the rules of appellate procedure. You can go to the court. You can ask them what the appeal deadline is. You need to find out, as soon as that judgment is entered, how much time you have to appeal the case. Most courts enforce this strictly. If you're 1 day late, you're done. The case is over. So if you're going to appeal it, you need to make sure, first of all, that you do so timely. A couple of considerations in determining whether you should appeal a case. The first one is, in most situations when you appeal a ruling, it's not a situation where the higher court or the Court of Appeals comes in and retries the case, or looks at all the evidence and tries to determine whether you actually owe the debt or whether the junk debt buyer proved their case. In most situations, what they're doing is they're looking at it from what's called an abuse of discretion standard. What this means is they're not looking to the evidence per se to say, hey, did the plaintiff prove their case? They're looking to the actions of the judge that heard your case, and they're going to say, did she, when she made her ruling, did she follow the law? Not only that, but they're looking to see if she abused her discretion, because the law affords judges a lot of discretion in determining whether the plaintiff proved their case. And so they're going to look to say, it's possible that the Court of Appeals could say, look, we don't quite agree with the final ruling that the judge did here, but it's not so far out of the bounds that we're going to reverse it. The judge was in there within their discretion to be able to do it. So the standard is different than a lot of people think when they appeal a case. Many people think that essentially they're getting a second bite at the apple. They're going to retry the case. In most situations, that's not accurate. They're just looking to see, did the judge that did the trial follow the rules and the law that's applicable in your state, and were they within their discretion in being able to do so? Third thing to consider when it comes to appeals, they're usually fairly lengthy. In my state of Arizona, an appeal, even in a justice court appeal, can take almost a year to get some kind of ruling. If we're in the higher court, the Superior Court, or the Court of Appeals, it can take up to 18 months to get a ruling. And in many situations, you have to post a bond. Otherwise, the collector can continue to try and collect on that debt while the appeal is pending. So that's something to be, thinking about. The appeal, sometimes the cases are, there's a good situation where an appeal is warranted. A lot of times, though, I say to look to some of these other options we're going to discuss here as a way to try to resolve it. So let's talk about that. The second thing that you can do if you happen to lose your debt collection lawsuit is you can engage in settlement discussions with the junk debt buyer. Now, a lot of people are surprised to find out that the junk debt buyers, they may offer some type of settlement before the case goes to trial, and surprisingly, they'll probably offer something quite similar even after a judgment has been entered. And so you can put together what I call a settlement budget. You can figure out, can you do a lump sum? Can you do monthly payments? And you can reach out to the creditor, to the junk debt buyer, and offer a settlement proposal. Even though they have the judgment at that point, they'll likely take a discounted amount because that's a lot easier than trying to garnish wages or garnish bank accounts. At the end of the day, a judgment doesn't mean money in their hand. It means that they have the ability to use some additional tools like wage garnishment, bank levy to try to collect. And so if you can help them have to avoid going through that whole secondary process to try to collect on this, then they should be willing to discount the judgment somewhat. So the main thing here to know is that once the judgment is entered, you need to act fairly quickly, because once they have that judgment, in most states, they can then do wage garnishment and they can do bank levy. And if they get a wage garnishment in place where they're starting to take money out of your check every 2 weeks, the chances of getting any kind of settlement are almost none, because they can tell you to pound sand and they're going to get that check every other week until that judgment is paid in full. Plus, they're usually going to get interest on top of it. So if you're going to offer some type of settlement, reach out fairly quickly. This can even be done before you appeal it. Sometimes you can use the appeal as a little bit of leverage and let them know that you are going to appeal it, but in exchange for a lower settlement, you'll agree to dismiss or waive your appeal rights on it. So those are some ways that you can try to position yourself, even though judgment's already been entered, to try to get some type of lower settlement. Let's talk about the third option. This is the nuclear option, bankruptcy. Bankruptcy will knock these things out of the water completely. When we're talking about credit card judgments, junk debt buyer judgments, almost always they will be discharged in a Chapter 7 bankruptcy and mostly eliminated in a Chapter 13 bankruptcy. So if you have particularly if it's a large judgment, or let's say you have a judgment from your debt collection lawsuit and you're dealing with a whole lot of other debt, medical bills, credit cards, that kind of thing, you can file a bankruptcy case, particularly Chapter 7 bankruptcy, and eliminate that completely. It'll void out the judgment, get rid of the underlying debt, and the case can be done with. There's obviously consequences to filing bankruptcy. Chapter 7 bankruptcy stay on your credit for 10 years. My experience is I see people recover credit score wise about 3 to 4 years after a Chapter 7. Like lenders like FHA will do mortgage loans 2 to 3 years after a bankruptcy filing. Other lenders are 3 to 4. So those are three options. If you find yourself in a situation where you've lost your case, whether it's a summary judgment or you went to trial and lost, you do have some options still. You can appeal it, you can settle it, or you can file for bankruptcy. So hopefully that helps. If you have any other questions, go ahead and put them down in the comments. I do review those, and I try to provide some information that I can. I can't provide specific legal advice because obviously I'm only licensed to practice in Arizona, and I don't know all the specific statutes, but I'm happy to provide any information I can or direct you to different resources that can help you to deal with your case. So thanks for watching today.